Here in the field of the state of care, the state of cause limited.
Mr. Jones, Mr. Mountford, before we start, Lord Richards has drawn to our attention an authority that doesn't appear to have been submitted, and I draw to your attention so that you'll have an opportunity to look at it over the short adjournment. It's the United States of America and Nolan, 2015 UK Supreme Court 63, 2016 appeal cases 463, and there's a passage in the judgment of Lord Mance at para 14 in which we're interested. Thank you.
My Lord, I'm grateful for that, or I will review it over the short adjournment and see how grateful we are. But, my Lord, thank you for that, and good morning, my Lords, my Lady. I appear with Miss Kelly Lythe for the appellant, and, as you know, Mr. Mountford and Mr. Murphy appear for the respondent. I intend to make some introductory comments, and at the end of those, to map out the shape of the rest of my submissions. Mr. Augustine worked, as you know, as a part-time private hire driver. Now, he was towards the higher end of what you might call part-time in terms of the hours that he worked. He worked about 35 hours per week on average. The Employment Tribunal does not define a cut-off point in this case between part-time and full-time, but they place some emphasis on the fact that the average was 43 hours. All drivers had to pay what was called a circuit fee, which was £148 per week. Now, this claim is not by any means a high-value claim, but just to put that in context, Mr. Augustine's evidence was, and this was not, I think, disputed, that drivers had to work around 22 hours per week just to cover the circuit fee. In the context of discrimination against part-time workers, it is necessary, where appropriate, to adopt a pro rata approach to the treatment in question. And if one looks at this circuit fee through the pro rata approach, the result is that Mr. Augustine was paying more per hour, or to look at it through the other end of the telescope, taking home less per hour than a full-time comparator. So that is the less favourable treatment about which complaint is made, taking home less pay per hour. And the question before you is whether that less favourable treatment was on the ground that he was a part-time worker. Now, as a first step on the road to showing that it was on the ground that he was a part-time worker, I say that it was on the ground that he was a part-time worker because it is inherent in a system which levies a per-hour charge that varies according to how many hours a driver works, that it will treat part-time workers less favourably than full-time workers. So, to put that more simply, a flat circuit fee will always treat, on a pro rata basis, part-time workers less favourably than full-time workers. It's inherent in a flat fee of that nature. And I don't understand that basic starting point to be in dispute. I'm going to come towards the end of my submissions to remind you, I'm sure you don't need reminding, but I should just show you the JFS decision of this court, which of course deals with the question on the ground and sets out some general principles about how one identifies treatment on the ground of protected characteristic, or here a protected status. In very broad terms, what this court said in that case is that one has to look for the reason for the treatment, which might be a discriminatory state of mind, it might be intentional in that sense, or it might be the application of a criteria which is itself either expressly or inherently discriminatory. in other words, inherently tied to the protected status. And that's why when I explained why the treatment here is on the ground that he's a part-time worker, I emphasised that it's inherent in a flat fee when looked at on a pro rata basis, that it will treat part-time workers less favourably. Now, the next question is...
Can you just give us a page reference to where we'll find that in? I mean, at some convenient time.
Yes, well, I will give it to you now, and I will show it to you. My Lord, in fact, why don't I show it to you now, since we're on the point? It's in tab 54, page 630. So the case actually starts at 593. There are 5 speeches for the majority, and I will give you the references to the others. I'm only going to show you one, because with respect to the others, Lord Mance puts it in the most pithy way in these passages here on page 630, where he says, direct discrimination can arise in one of 2 ways, because a decision or action was taken on a ground which was, however worthy or benign the motive, inherently racial, within the meaning of section 1(1)(a), or because it was undertaken for a reason which was subjectively racial. You'll see a bit further down, in the Birmingham case, girls were required to achieve a higher standard than boys for grammar school entry because of a disparity in the number of grammar school places available for boys and girls. Whatever may have been the intention or motive of the council, nevertheless it was because of their sex that the girls in question received less favourable treatment than the boys, and so were the subject of discrimination. It was for the council to find some way of avoiding this, such as by balancing the places available. In the James case, the motive for adopting as the test for free entry to the swimming pool to people who'd reached state pension age was no doubt benign. It was probably because they were perceived as more likely to be needy. But being of pensionable age is not to be equated with ceasing to work or being in receipt of a pension, and the difference between the ages at which men and women became of pensionable age made the test inherently discriminatory on the ground of sex. And, my Lord, that James case, you will see, is a good example of inherently discriminatory treatment, because the criteria that's actually applied there to decide whether or not men and women get free entry to a swimming pool is whether you're of pensionable age. So it's not a criteria which expressly is discriminating between men and women, but it's inherent in it that it was discriminating between men and women because men and women had different pensionable ages. My Lord, I said I'd give you the references to the other speeches. Lord Clark simply says that he agrees with Lord Mance. Lord Kerr said... Is there a page number? Or don't worry. Don't worry, we'll find it. I've got the page numbers for my other references, but not that one, but I'm sorry. Lord Kerr at paragraphs 113 and 114. Lord Phillips at paragraphs 13 to 23. And Lady Hale at paragraphs 58 to 65. And, my Lord, just while we've got this open, one difficulty with several of the cases that we are going to have to look at, including McMenemy, which is the Court of Session case, which emphasises sole ground, sole reason, is that they predate this JFS case and they enter this field in a context where there were debates and uncertainties about what on the ground meant, and in particular about whether one had to show intention or not. So there are references in McMenemy, which I will show you, to a need to show intention, which is wrong, and it's not contested that that is wrong, but that is weaved through some of the reasoning in McMenemy. And
sorry, Nagarajan and Khan had already been decided before McMenemy
that's right.
was decided, and they made clear that conscious that an intention or a motivation was irrelevant.
I accept that, my lady, but nonetheless, there were cases which continued to raise these as debates. There are also the ongoing debates about the but-for test, which get referenced in various of the cases. The test
doesn't really matter, though, at all this, does it? I mean, what matters is what the right answer to the question is.
That's right. That's right, my lord. We can put that away. Lord Clark, my lady.
Thank you.
Page 650, paragraph 132.
Thank you.
Are we asked to apply the test to the facts in this case, or is it accepted on each side that the result of the legal question determines the outcome?
My lord, can I take that away? I think the answer is it's accepted on...
Well, there's nothing about the facts in your respective cases. It's all about the legal issue.
It's all about the legal issue.
So I wondered whether the EAT's decision is challenged on that point. It doesn't seem to be.
No, my lord, not on that point. Back then, just to the facts of this case to see how the issue arises. It's on the ground of part-time status. Obviously, the next question, and the important question, is the less favourable treatment only caused by his part-time status, or are there other causes? Now, the answer to that question is that you can explain some of the difference in take-home pay, or if you like, in the amount that he was paying per hour for the fee, by the fact that he worked part-time. However, it is also true to say that if he worked full-time, he might be disadvantaged compared to the comparator, because the comparator who he chose was working 90 hours on average per week. So if one imagines if he was working 45 hours per week, he would still be at a disadvantage compared to that full-time worker who he had chosen as a comparator. Now, that partly has a consequence for his compensation and his entitlement to compensation. And it's been accepted, at least since I was involved in the EAT, that when the tribunal comes to award compensation, it can take that into account. In other words, it is entitled only to address and remedy that part of the difference in treatment which is attributable to his being part-time.
Well, why isn't that part solely attributable to his being part-time?
Well, my lord, that is another way of looking at this, and another way of asking a similar question would be, what if he had chosen a comparator who worked, as it were, exactly the cut-off of full-time? And now, he may well not have been able to choose such a comparator. I don't know that there was one. And in fact, the way this unfolds in the employment tribunal is that you have to identify your comparator, and then they need to decide whether that person does or doesn't work full-time by reference to evidence on the culture at the employer and the practice at that particular employer. So
he chose someone who hardly ever gets out of the car.
Well, he did. And that, of course, is standard in these cases when one chooses a comparator. So that is right. But so he chose someone who...
Is it, under the legislation, is it a matter for the claimant to choose his comparator?
Yes.
I see.
Yes. And there's then a question of whether, I'll show you the provisions, whether they are a valid comparator along various different variables, the type of contract they have, and so on and so forth, but one can, within those confines, choose comparators. And what often happens, and I don't know that this necessarily happens in this case, but what often happens is that one gets disclosure of information about potential comparators before choosing which comparator one is then going to use. And typically the claimant will choose the one which looks the most beneficial from their perspective.
I mean, it seems to me there's a difference between someone working full-time and someone working a huge amount of overtime, as a matter of the regulation, which requires a comparison with a full-time worker.
Well, I'll show you the definitions on full-time and part-time. It's, I think, important to keep in mind that in this particular context, they were at the time treated by the employer as though they were self-employed.
Oh, I know, but that's been held to be wrong, hasn't it?
That's been held to be wrong, but the only reason I make that comment is that there wasn't a question of doing overtime as such. Because there wasn't a contracted basis for working in a particular number
But
of hours.
is the answer to my Lord's point that when it comes to the compensation exercise, the tribunal should only award compensation for the differential as between, 35 hours and, say, 48 hours, 43 hours?
Yes.
Anything more was attributable to overtime or longer full-time, whatever else you want to call it.
That is absolutely right. And in this particular case, the comparison has to be between the claimant and the person he's chosen as the comparator. So the answer to the question which you posed me directly is that there are two causes, if you like, for that difference, and it's partly attributable to part-time status and partly attributable to the fact that his comparator works an enormous number of hours. So that's the straight answer. And the reason I make the point about imagine if he had chosen a comparator who works exactly the full-time hours, well, as I understand Milena's friend's case, he'd have to accept that the claimant would have got the compensation. And it's only because of the comparator who he's chosen, and as I said a moment ago, he may not have been able to choose someone who worked precisely the full-time number of hours. So it's only as a consequence of that feature that it is now said, well, there are multiple causes and therefore he's not entitled to any compensation. Parliament has used in the regulations the language on the ground that. I've shown you JFS. It is well familiar language in equality and discrimination law, and it is well established that it can encompass multiple cause cases. Could I show you the...
And that was well established before the 2000 regulations were introduced.
It was, my lady. I was going to show you Nagarajan. Can I go to that first, which actually was a fortnight after the regulations, and then I'll show you a prior case.
Yeah.
So Nagarajan is page 527, so tab 51. The claimant, in this case, had failed in his application for a position as a travel information assistant. The relevant provisions are set out on page 543. You'll see at the bottom of that page, section 1.1 of the Race Relations Act, a person discriminates against another in any circumstances relevant for the purposes of any provision of this Act if A, on racial grounds, he treats that other less favourably than he treats or would treat other persons.
And just pausing there, Mr. Jones, on grounds, plural, in the Race Relations Act, is simply to reflect the fact that racial grounds comprise colour, nationality, ethnicity, rather than it being a plural grounds point.
Absolutely right, my lady. And the case I'm going to come to is a sex discrimination case, the O'Neill case.
Well, in the 75 Act, it was just singular ground.
Singular ground. I want to pick up the speech of Lord Nichols, page 536, please. In which, at the bottom of that page, at H, it's explained to be within section 1.1a, the less favourable treatment must be on racial grounds. Thus, in every case, it's necessary to inquire why the complainant received less favourable treatment. This is the crucial question. Was it on grounds of race, or was it for some other reason, for instance, because the complainant was not so well qualified for the job? And then the key passage for our purposes is over on 538 from H. Decisions are frequently reached for more than one reason. Discrimination may be on racial grounds, even though it's not the sole ground for the decision. A variety of phrases with different shades of meaning have been used to explain how the legislation applies in such cases. Discrimination requires that racial grounds were a cause, the activating cause, a substantial and effective cause, a substantial reason, an important factor. No one phrase is obviously preferable to all others, although in the application of this legislation, legalistic phrases, as well as subtle distinctions, are better avoided so far as possible. If racial grounds or protected acts had a significant influence on the outcome, discrimination is made out. And that passage is a very well-known passage in discrimination law and has been cited in many, many cases since this particular decision. You will see within that passage that I just read out that Lord Nichols was making the point that these principles have been referred to in many prior cases. I underline that because my lady's already anticipated the point, which is this judgment, as it turns out, postdates the 2000 regulations by a fortnight, but it isn't setting out a new principle, and I will show you one of the prior cases, and I'm going to show you this case because it's the one which is referred to in the courts below in these proceedings. It's the O'Neill case. It's in tab 53 if you have tabs, page 577. You'll see on the head note there that there was an argument, the claimant argued she brought a sex discrimination claim. The Industrial Tribunal dismissed her claim of sex discrimination, I'm picking it up halfway through the first paragraph, on the ground that she had not been dismissed because she was pregnant, but because the pregnancy was by a Roman Catholic priest and had become public knowledge, making her position as a teacher of religious education untenable. So that was the finding of the Industrial Tribunal, and if we go forward to page 587, we're in the judgment of the then President of the EAT, Mr. Justice Mummery. And page 587, you'll see at D, a condition of liability is the expression in the expression on the ground of her sex is an objective test of causal connection. And what is said at B is in answering that causation question, regard must be had to the well-established and uncontroversial legal principles recently discussed by the Court of Appeal in Bruxelles. Although the case was not cited in argument on the appeal, there can be no doubt that the principles discussed in that passage are beyond controversy at this level of decision, and there are then various principles set out, and within those what is being emphasised is you'll see at little 3 at the bottom there, the approach to causation is further qualified by the principle that the event or factor alleged to be causative of the matter complained of need not be the only or even the main cause of the result complained of, though it must provide more than just the occasion for the result. It is enough if it is an effective cause. Now I show you that, I explained why I show you that. I would make this point as a footnote, which is the Nagarajan approach explains in essentially the same sort of language the approach which should be taken in equality law. As I said, that's been followed in many other cases. I'm mentioning that footnote because bringing in tests from completely different contexts where concepts such as but for may play a stronger or a different role might lead us into the choppy waters of causation which arise in other areas of law. So I emphasise the Nagarajan approach. I'm not saying it's different from O'Neill. I'm simply saying that being cross-fertilised from other areas of the law has at least the potential to lead one into choppy waters. The simple reason why I say that is that, as we know from JFS, the focus here has to be on the reason for the treatment, which is not always the same as a but-for test. I have to deal, of course, with the fact that the framework agreement on part-time work, which is what is given effect to by the directive on part-time work and then implemented via the domestic regulations, refers to less favourable treatment, quotes, solely because the person works part-time. And those words, solely because, are the words which caused the court in McMenemy to say that one can't have essentially multiple cause cases. In summary, I say that those words are simply intending to focus on the fact that the less favourable treatment must be on grounds of part-time status and not for some other independent reason. They are not intending to rule out the possibility of there being multiple causes. They are intending to rule out the possibility of a finding of less favourable treatment in cases where part-time status is not a cause of the less favourable treatment. And I will, of course, be developing that in detail, but I want to flag just at the outset that that argument is, I say, given very strong support by a judgment of the CJEU which postdates the Court of Appeal's decision in this case, called Laufey, which is a case actually about fixed-term workers, but the provisions are identical. And the judgment in my submission makes absolutely clear that the framework agreement covers less favourable treatment in multiple cause cases. That brings me to the end of my introductory remarks.
And the reference to that case?
My Lord, I'm going to spend a moment on it. It is in the bundle at tab 65 from page 846.
Thank you very much.
I'm going to structure my submissions in this way, under 6 headings. Firstly, the legislative framework, which will cover the regulations and the directive. Secondly, 2 key authorities. And the 2 key authorities are the decision of the EAT in a case called Sharma and the Laufey case, which I just mentioned. Third heading, additional materials concerning the directive. Fourth, should the regulations be interpreted consistently with the directive? Fifth, the case of McMenemy. And 6, the decisions in this case. So I start then with the legislative framework and with the regulations. They are in the bundle at page 236. You will note on the first page that they were introduced in exercise of the powers conferred by Section 19 of the Employment Relations Act 1999. I just note that now. I will return to its significance in due course. Over the page, 237, you'll see a definition of employer, and that definition covers people who employ employees and workers. The regulations generally protect employees and workers. There's a definition you will see of the pro rata principle, which I've touched on. It's not in dispute any longer how that applies in this case. In Regulation 2, there is a definition of full-time worker. A worker is a full-time worker if he's paid wholly or in part by reference to the time he works and having regard to the custom and practice of the employer in relation to workers employed by the worker's employer under the same type of contract is identifiable as a full-time worker. And then underneath that, there is a definition of part-time worker, which is essentially someone who is not a full-time worker. You'll see in 2.4 a definition of a comparable full-time worker. So to bring a claim under these regulations, a part-time worker has to identify a real comparable full-time worker. And I'm emphasising that because that is different to a lot of other branches of discrimination law where one can come up with a hypothetical comparator. This serves, and this is a point which my learned friends make, and we accept it, this does serve to significantly narrow the scope and the reach of these regulations, because one can only bring a claim if there is a comparable full-time worker. And you'll see the that there is a comparable worker if both workers are employed by the same employer under the same type of contract and engaged in the same or broadly similar work, having regard to whether they have similar level of qualifications, skills and experience, and in B, the full-time worker works or is based at the same establishment as the part-time worker, or where there's no full-time worker working or based at that establishment who satisfies the requirements of subparagraph A, works or is based at a different establishment and satisfies those requirements.
And would that would be an answer to the EAT's example in Sharma?
No.
No.
It wouldn't.
It
I'm going to come
the respondents say it would, but you'll come to that.
The respondents say it would, but I'll come to that. Over the page, Regulation 5, page 239, this claim before you has been brought under Regulation 5. A part-time worker has the right not to be treated by his employer less favourably than the employer treats a comparable full-time worker, A, as regards the term of his contract, or B, by being subjected to any other detriment, by any act or deliberate failure to act of his employer. The right conferred by paragraph 1 applies only if A, the treatment is on the ground that the worker is a part-time worker, and B, the treatment is not justified on objective grounds. Now, of course, 2A, on the ground that the worker is a part-time worker, I've shown you some authorities on the meaning of on the ground that, but one obviously needs a provision like that to state the obvious, because otherwise one could simply point to someone who's a full-time worker and say that there's a difference in treatment without needing to show why there is a difference in treatment. The words only if at the end of 2 are setting the conditions which have to be satisfied for a part-time worker to succeed in the claim. So the part-time worker, of course, has to show that the treatment is on the ground that the worker is a part-time worker. But that is not the same, for reasons I've already touched on, as saying that the worker has to show that the treatment is on the ground that the worker is a part-time worker and no other additional causal factor.
It doesn't say on the sole ground.
It doesn't say on the sole ground. Regulation 8 on page 240, you'll see that a person may present a complaint to an employment tribunal. Over the page, at Regulation 7, where an employment tribunal finds a complaint presented to it is well-founded, it shall take such the following steps as it considers just and equitable, and that includes compensation. And at subparagraph 9, considering just and equitable, the tribunal will have regard to A, the infringement to which the complaint relates.
Sorry, I've missed where you're reading from.
Where you're reading, is it
I apologise.
on 241?
241.
241.
Paragraph 8.
241, and subparagraph 7
Yeah.
is the just and equitable compensation. And at subparagraph 9, various factors shall be taken into account, including the infringement to which complaint relates and any loss which is attributable to the infringement. I will show you briefly how these various stages were dealt with in this particular case, just to put it in context. Page 162, please, is the judgment of the employment tribunal. They set out the issues as they saw them on page 163.
She, not they, I think.
No, that's correct. She recorded there that issue D, objective justification, was not actually a live issue because the respondent said, and you'll see this in paragraph 5 at the bottom of page 163, that they would not be arguing objective justification if they lost on the less favourable treatment grounds. And going forwards to page 168, paragraph 17 is where you get the numbers which I gave you earlier. The respondent's evidence was that the claimant worked 34.8 hours per week on average. This compared with an overall driver average of 43.17 hours weekly. These figures were not challenged by the claimant. The decision that he was a part-time worker follows detailed reasoning, but I'll just show you the conclusion at page 172, paragraph 38. What I've skipped over is a discussion about the fact that the tribunal had some doubts about this, but following the claimant's success in a different case before the EAT, the tribunal came back to the question of whether he was part-time and decided that he was. The comparator who he chose, you will see at paragraph 39, worked an average of over 90 hours per week.
So can you choose more than one comparator in these regulations? Or can you only choose one?
I don't see why one couldn't bring a claim.
Okay, but he only chose one.
He only chose one.
Yeah.
On the question of whether he was treated less favourably than the full-time comparator as regards the terms of his contract, the Employment Tribunal dealt with this in two stages. It starts from page 172, and this is history really, but just to show you, on page 174, paragraph 49, the conclusion was that actually they were both treated identically because they both had to work essentially the same number of hours to cover the fee. But they then, from 174, you'll see paragraph 50, in case I'm wrong on that conclusion, went on to consider it by applying the pro rata principle in the way that the claimant said should be applied, and they agreed over 175, paragraph 56, that if one applies the pro rata principle, then there was less favourable treatment. That was the focus of ground one of his appeal to the Employment Appeal Tribunal. That has not been appealed. We don't need to go into the details. I'll just give you the reference to the EAT's judgment on that point. It's at page 136, paragraph 33, where they essentially endorse the reasoning here at paragraph 56, so the alternative reasoning, and say that the tribunal was wrong in its primary reasoning. We then come to the question, was the less favourable treatment on the ground that he was a part-time worker? And this is addressed from page 175, paragraph 58.
Sorry, forgive me, paragraph?
Paragraph 58.
Thank you.
And you'll see in 59, what the tribunal says is the evidence of Mr. Chapman and Mr. Townsend demonstrates that the model whereby private hire vehicle companies charge drivers a circuit fee or rent in order to access bookings is well established. I accept that it's likely that many private hire companies operated in this way until the arrival of Uber introduced a different commission-based model based upon a sophisticated software booking system. It was the way in which these companies earned their revenue. And that is essentially the basis on which the tribunal then reasons that the ground was not part-time status. They say the reason for the treatment is that this is how the company earned its revenue. And there are several references to this, but I'll just show you the conclusion, page 178. Picking it up 3 lines down, the claimant was not charged the full circuit fee simply because he worked fewer hours than other drivers. The reason why he was charged the fee was so that he could obtain access to bookings through the respondent systems in the same way as any other driver. Now, I say that line of reasoning is plainly wrong because that is a justification, if it's anything, for the treatment.
Well, it's not an issue anymore, is it? This is all just part of the history of the case, because it tells us that the only question is the question of law.
My Lord, that's right, although Yes, my lord, that is right, and I'm simply drawing a distinction between justification and reasons because it comes up in some of the other cases. But my lord is right about that, and the way that this is resolved in the EAT, I'll show you that briefly because this is now the basis for this decision. It's page 153. Paragraphs 87 and 88 in particular. Asking whether the charging of the flat rate circuit fee was on the sole ground that the claimant was a part-time worker. Now, this is where they bring in their analysis of sole ground and why it's not on the sole ground. We're unable to say that ET would have been bound to find that was the case. As the ET found, the respondent's drivers worked a wide range of hours. The less favourable treatment identified by the claimant arose from the failure to apply a fee that took into account hours worked. As such, it might be said that at least in part the claimant was treated less favourably because he worked part-time, but the same would be true of the many drivers who would be characterised as working full-time. So that's the logic which I described at the outset of my submissions, and that really is the basis of the EAT's decision, that there is more than one ground, more than one reason for the less favourable treatment. Could I turn next to the directive? It's at tab 35, page 297. You will see in paragraph recital 8 on that page that there had been a request by some employers, confederations, the European Centre of Enterprises with Public Participation and the European Trade Union Confederation to initiate the procedure provided for in Article 4 of the Agreement on Social Policy. And what that procedure envisages is a process whereby these social partners, so-called, come together and are able to negotiate an agreement which may then be put into effect through a directive, as happened here. Recital 9, you will see that they had forwarded a request to implement their framework agreement. Recital 11 records that the signatory parties wish to conclude a framework agreement on part-time work, setting out the general principles and minimum requirements for part-time working. Over the page, recital 16 says, whereas with regard to terms used in the framework agreement which are not specifically defined therein, this directive leaves member states free to define those terms in accordance with national law and practice. So anything in the directive which is not defined is explicitly left to member states. You'll see down at the bottom of 298, there's Article 1 explains that the purpose is to implement the framework agreement, and Article 2 is very briefly saying that the member states shall bring into force laws, etc., required to implement the framework directive. And it then annexes the framework directive from page 300. And in the preamble, the second paragraph explains that the agreement sets out the general principles and minimum requirements relating to part-time work. Page 301, clause 1 helpfully sets out the purpose of the framework agreement, and it is twofold. A, to provide for the removal of discrimination against part-time workers and to improve the quality of part-time work. And B, to facilitate the development of part-time work on a voluntary basis and to contribute to the flexible organisation of working time in a manner which takes into account the needs of employers and workers. There are definitions in clause 3, and the principle of non-discrimination appears in clause 4. In respect of employment conditions, part-time workers shall not be treated in a less favourable manner than comparable full-time workers solely because they work part-time, and less different treatment is justified on objective grounds. And lastly on this, I will just show you over the page 302 at clause 6, paragraph 1. Member states and or social partners may maintain or introduce more favourable provisions than set out in this agreement. That's the legislative framework. My next heading, number 2, was 2 key authorities. And the first authority that I want to show you is the case of Sharma, which is in tab 56 at page 732. I should say there are many conflicting EAT decisions on the issue which is before you, and I am only going to take you to this one, plus the one which is in our particular case. I'm going to this one for 2 reasons. One is that it gives a very pithy summary of what I say is the correct approach, and essentially the answers to all of the points which are made, all of the main points which are made against me. And the second reason I'm going to this is that it is really a direct analogue of the Lalfi case at the CJEU, which I mentioned in my opening submissions, and which I'm going to come on to after this. So I want these 2 cases to be seen together. I should say Sharma post-dates the McMenemy case, but doesn't have McMenemy cited to it. So everything that is written here is blind to what had been said by the Court of Session in McMenemy. And the facts of this case in brief is that there were part-time lecturers who had a term in their contract which enabled their hours of work to be reduced. And they brought a claim in which they compared themselves to full-time lecturers who did not have such a term. And their complaint was partly about the existence of the term in the first place, and partly about the fact that it had in fact been relied on and their hours had then been reduced. So that was the context. Now, they were met with the argument, which succeeded in the employment tribunal, that this term did not appear in the contracts of all part-time workers, but only a subsection of them. And therefore, the employment tribunal reasoned, the less favourable treatment was not solely on the ground of their part-time status. Rather, it was on the ground that they were a particular type of part-timer. And the case then came before the EAT, chaired by the then President, Mr. Justice Elias. And if we can pick it up, please, at page 741, you'll see at the bottom there the heading, the sole issue, the sole reason issue. At 47, as we have said, the tribunal apparently considered it was bound by the decision, interposed decision of the EAT in Gibson Scottish Ambulance Service to conclude that part-time nature of the worker status had to be the sole reason for the discriminatory treatment. We have no doubt that this is not a legitimate construction of the regulations, and in Gibson itself, the appeal tribunal hardly gave a ringing endorsement of the construction. In our judgment, the reference to solely in Directive 9781 is simply intending to focus upon the fact that the discrimination against a part-timer must be because he or she is a part-timer and not for some other independent reason. And I agree with that. And that was the way that I put this in my submissions a moment ago. My lady, this is where we come to the examples. To take a simple example, if the employer decided to discriminate against all part-timers over the age of 30, it could be said that there were 2 reasons for the discrimination: being a part-timer and being of a certain age. I'll just pause there to say that that is correct. What is said against that is, well, they could bring an age discrimination claim. True, they could. He goes on, similarly, if the employer deliberately discriminates against all his part-timers in Factory A, but not those with identical full-time comparators in Factory B, can it really be said that because only some part-timers are selected for the less favourable treatment, the directive, and by extension the regulations, are not intended to be applicable? Now, you may have seen a reference in I think it's mentioned in the Court of Appeal's judgment and also my learned friend's case, to me describing that as an imperfect example. And it's a valid example. It's imperfect in the sense that it's just a bit more complicated than it needs to be, because the simple point which is being made here is that if there is a category of part-timers who are discriminated against, it would be very odd for that not to be caught by the regulations. And you can think of many different examples of categories of part-timers, people who maybe don't work weekends, or part-timers who signed their contract after a particular date. Obviously,
what was the basis in that case itself as to how the lecturers have been differentiated?
They had different terms in their contracts. So
I know, but what was the reason, or not the reason, but what was the explanation for why some had one term and the others didn't? Is there some criterion other than such as the date? Or
no, it wasn't a criteria such as the date. I'm not sure that the case explains what was the underlying reason for all of that, but there were different categories of part-timers whose contracts contained different terms. So there are many examples which could be given of this, which would make the point. And
on that first example, it only works, doesn't it, if no distinction is made as regards full-timers between those over and under the age of 30.
Yes. Yes.
In which case, I find it a very odd example, because clearly it is discrimination on grounds of being a part-time worker, because it applies only to part-time workers or to a subset of them.
Well, yes, but if your comparator...
Comparator is a full-time worker.
If your comparator... That's right, but if your comparator was a full-time worker...
no, it's because there are part-time workers under 30 who are not being less favourably treated, and that would suggest that the over 30-year-old part-timers who are being less favourably treated aren't being less favourably treated on grounds of part-time status. That's why it works. But
that's the shape of the problem. If you're applying two criteria and you're only treating workers less favourably if they, as it were, satisfy both of those criteria, then there is more than one.
The comparator is with a full-time worker, isn't it?
Yes, the comparator is with a full-time worker.
Not with another part-time worker.
That's right, but what one needs to do is firstly show that there's less favourable treatment between the claimant and the comparator.
Yes.
And then ask what is the reason for that. And when you ask what's the reason for that, one can draw in wider evidence, potentially ask hypothetical questions. And
well, you wouldn't have to ask a hypothetical question here. The employer would immediately say, I don't discriminate against part-time workers. Look at this group who are under 30 who aren't treated in that way.
That's right. That's and so if
that would be
the evidence
answer.
led you, but one would look to the treatment of other part-time workers because it would be being raised by the...
Personally, I don't find it a very convincing answer, but there we are.
Well...
but there we are. I mean, it's just an example he was giving.
It's just
no
an
doubt
example.
one could find others.
The second example, I'm afraid, is even more complicated, but I'll spend a moment on it because it perhaps...
But your basic point is if there are two criteria that have to be satisfied, only one of which is being a part-time worker, then you can't say that it's solely because you're a part-time worker that you're getting that unfavourable treatment.
That's right, because obviously the age element makes this difficult because no employer is going to want to say, oh, it's not because you're part-time, it's because you're aged over 30. So that's partly why this is a sort of awkward example to talk about, because no one's going to want to say that. But if age discrimination were not unlawful, and we stick with this example, then the employer would want to say, oh, it's not because you're part-time, it's because you're aged over 30. And there would then need to be an assessment of whether that is correct, or whether it's because you're over 30 and part-time. And that's the point. If there are two criteria that are being applied, over 30 plus being part-time, then part-time status is an effective cause. It is inherent in a policy like that you're going to be discriminating against part-timers, albeit that it's also inherent that you'll be discriminating against people on grounds of age. The factory example is very similar. And, my lady, the way Again, the reason this is complicated is because I showed you in the regulations that one really has to, if there is a comparable full-time employee in the establishment that the claimant works in, then that person should be the comparator. But what's being posited here is a situation where part-time workers in different factories use the same comparator. Now, that only works if you start from the premise that there are no comparable full-time workers in factory A. So that's the situation. No full-time workers, no comparable full-time workers in factory A. There's a part-time worker in factory A who compares himself to a full-time worker in factory B, and the tribunal then would have to work out why is it that this part-time worker in factory A is being paid less than the full-time worker in factory B. And that would require evidence. The employer might say, nothing to do with being part-time, it's because you don't work weekends. They might say it's nothing to do with being part-time, it's because you work at factory A, in which case one might have to think of hypotheticals. What if a full-time employee worked in factory A? How much would they be paid? But if the evidence leads you to a conclusion from the facts that what is happening here is a decision to treat people who satisfy two criteria, part-time workers in factory A, less favourably, then it is another example of compound reasons. And it's another example which I say is within the scope of the regulations. Can I show you at paragraph 52? Oh, I'm jumping ahead, I apologise. Paragraph 50, we're back in the judgment on page 742. Paragraph 50, in our judgment it's inconceivable that the directive was not intended to outlaw such treatment, subject to justification. We have no doubt whatsoever that it would inevitably be construed by the European Court of Justice to do so. Any other conclusion would wholly undermine the very purpose of the directive. The fact that not all part-timers are treated adversely does not mean that those who are cannot take proceedings for discrimination if being part-time is a reason for their adverse treatment. In our judgment, once it is found that the part-timer is treated less favourably than a comparator full-timer, and being part-time is one of the reasons that will suffice to trigger the regulations, it follows there's no defence along the lines that Appendix 10 was applied only to some but not all part-timers. The appeal must therefore succeed on this point alone. They then say, in any event, as we indicate below, we think it's wrong to characterise the discrimination as being for more than one reason. Properly analysed, it was only because the claimants were part-timers. Now, I'm going to come back to that in a moment. It adds another layer of complication, which doesn't really need to detain us, but I'll come back to it in a second. I'll just, before I do that, just highlight paragraph 53. We'd add that in any event, it's open to a member state to give more favourable protection than the directive affords. And accordingly, in our judgment, there's no need to read limitations in the directive into the regulations. In this connection, it's to be noted that the regulations were made under Section 19 of the Employment Relations Act 99, which confers a broad enabling power, not just limited to implementing the terms of the directive. And you will see why I say that those few short paragraphs essentially encapsulate my case today. Now, I skipped over that reference in 52 where they say properly analysed, we think it was only because they were part-timers. You will see that that is a secondary basis for the decision, not the primary basis. It's what's discussed under the heading, the second ground. It's a somewhat nuanced point. I've explained that the reasons in this case, if you classify this as a two reasons case, is firstly that they were part-timers, and secondly that they had this term in their contract enabling their hours to be reduced. And what the tribunal essentially goes on to say is that term is the very thing which is said to be discriminatory. And they say, well, in those circumstances, it's artificial to treat that as a separate ground. That's what the tribunal says. That's not an issue which arises in our case or in other cases, but just to explain why the tribunal goes on to make that secondary finding in that particular case. Now, I next want to turn then to Lalfi. It's not about part-time workers, it's about fixed-time workers, but I've said already that the provisions are essentially identical. Can I just show you briefly the fixed-term work directive, which is at page 204 57, and it works in the same way. It attaches a framework agreement. And if you go forwards to page 261, you will see in paragraph 1 there at the top of the page, identical provision for our purposes. In respect to employment conditions, fixed-term workers shall not be treated in a less favourable manner than comparable permanent workers solely because they have a fixed-term contract or relation, unless different treatment is justified on objective grounds. And I should say, for your information, the McMenemy decision is followed in this jurisdiction in fixed-term cases as well as part-time cases. Now, against that backdrop, I want to look at the Laufey case. It's in tab 65, which is page 846. By way of context, tenured teachers, in other words, permanent teachers, had access to a professional development fund. A previous decision of the CJEU had held that it was discriminatory, contrary to the Fixed-Time Workers Directive, not to give fixed-term employees access to that fund. If you look, please, at page 850, paragraph 15, the court, that's a reference to the referring court, states that following the delivery of the order in the earlier CJEU case, Paragraph 15 on page 850. The Supreme Court of Cassation in Italy held that non-tenured teachers who held supply teaching posts for the duration of the academic year were also entitled to the electronic card. It did not, however, explicitly rule on that entitlement as regards non-tenured teachers who held short-term supply teaching posts, which led to divergent case law from the trial courts on that issue. So the essential problem which arises is that after the Court of Justice has said fixed-term workers need to be treated in the same way as tenured workers, a distinction is drawn in Italy between fixed-term workers who work for the full academic year, who do get the benefit, and fixed-term workers who only hold short-term supply teaching posts, who do not. Now, if one asks the question, is that less favourable treatment on grounds of their fixed-term status, you will immediately see it's obviously inherent in the criteria that it will affect fixed-term workers compared to permanent workers. The criteria is if you are a short-term supply teacher, you won't have access. Being a supply teacher means being fixed-term. Is it only on that ground? Well, as you will see, it's very similar to the examples we were just discussing. Well, no, there's another ground, which is it's not enough just to be a supply teacher to be disadvantaged. You have to be a short-term supply teacher, so they are sorted according to the length of their fixed-term contract. It's less favourable treatment which only applies to a category of fixed-term worker. You'll see the questions referred over the page at 851, and the first question is Clause 4 of the Framework Agreement to be interpreted as precluding a limitation on the award of the electronic card based on the duration of the supply teaching assignment? And these questions, that question is considered in the round with the other questions. If I can pick it up, please, on page 854. You will see it. There are some preliminary comments which are made broadly about the scope of the agreement and whether this, in broad terms, falls within the scope. But if we go to paragraph 44, in the third place, in accordance with the objective of eliminating discrimination between fixed-term workers and permanent workers that it pursues, Clause 4.1 of the Framework Agreement prohibits, in respect of employment conditions, fixed-term workers from being treated less favourably than comparable permanent workers on the sole ground that they're employed for a fixed term unless different treatment is justified on objective grounds. So they emphasise the sole ground. They then go on at 45. To that end, the principle of non-discrimination has been implemented and specifically applied by the Framework Agreement solely as regards differences in treatment as between fixed-term workers and permanent workers in a comparable situation. And then at 46, in that regard, so far as concerns in the first place a difference in treatment for the purposes of Clause 4.1, it's apparent from the grounds of the order for reference that not only all tenured teachers employed on a permanent basis may be entitled to the card, but also non-tenured teachers employed on fixed-term contracts when they hold supply teaching posts for the duration of the academic year. And you'll see at 47 that that was an argument which the Italian government relied on. They said the Italian government concludes from that the questions referred for a preliminary ruling concern, in reality, a difference in treatment not between fixed-term workers and permanent workers, but between two categories of fixed-term workers, which is outside the scope of the framework agreement. So that was the argument that was put to the court. And it's rejected. At 48, they point out that the difference in treatment has been removed for some, but you'll see halfway through that paragraph, it continues by contrast in respect of non-tenured teachers holding short-term supply teaching posts. Thus, the removal only in part of the difference in treatment between tenured teachers employed on a permanent basis and non-tenured teachers employed under a fixed-term contract means that some non-tenured teachers are still subject to a difference in treatment as compared with tenured teachers. And then at 50, it follows that a difference in treatment for the purposes of Clause 4.1 of the Framework Agreement cannot be excluded on the sole ground that the difference in treatment affects only some of the fixed-term workers, since otherwise the scope of protection against discrimination conferred by that provision, which must apply to all fixed-term workers in accordance with case law referred to in paragraph 39 above, and as the European Commission has in essence already also observed, would be unjustly reduced. So you will see, I hope, why I say that this structure of this case is very similar to the structure of Sharma. It's another case in which a category of protected persons suffer the less favourable treatment. But it does not follow from the fact that it is only a category of them that they cannot bring a claim under the directive. And the argument that is run by the Italian government that it's difference in treatment between two categories of fixed-term workers is wrong. And they don't express it there as being there are two causes, but that is what they are describing. That's the situation that they are describing. Now, my learned friends say about this that it's considering the question of comparability, is what my learned friends say in their written case, that this is all about comparability. That isn't right. Everything that I have shown you is about the question of whether, under the language of the directive or the framework agreement, the difference in treatment is solely because they are fixed term. And you will see at 52, the court goes on to say, accordingly, it's necessary in the second place to examine whether those non-tenured teachers who hold short-term supply teaching posts are in a comparable situation to that of the tenured teachers concerned. the court, in other words, goes on afterwards in the second place to consider the question of comparability. And I'm underlining in the second place because if you turn back to page 854, you'll see what the first place is. It's at paragraph 46. In the first place, a difference in treatment for the purposes of clause 4.1. So it is not right to say that this reasoning that I have shown you, which I rely on, is about comparability. And my third heading is...
Rather, well, I know it's the way of these decisions. Not exactly much in the way of reasoning, is it, to say that it would be more just if a different result were reached?
My Lord, I shan't comment on the... it is... What it does demonstrate is when the President said in Sharma it's inconceivable that the Court of Justice...
His powers of prediction have been vindicated. So. I'm not sure what the sole ground is doing there either. The sole...
No,
but sole's in the wrong place there because we're not actually... Well, they're maybe addressing an argument indirectly based on solely because the argument itself isn't the sole ground. Actually, it's only one of a number of grounds, perhaps, on which they're relying.
My Lord, absolutely right. And I'm going to come to a case which uses the same language, talks about the sole ground. And it's a point which my learned friend relies on is that there are various CJEU cases which refer to the sole ground as well as sole reason. And I showed you in this case that the court refers to sole ground at paragraph 44. So there is a question, what does the court mean when it says sole ground? And my answer to that is just the answer which the President gave in Sharma, which is that they are simply emphasising that they are concerned with treatment which is on the ground of part-time status, not for some other independent reason. And that's clear in this case because they talk about sole ground even where, as my Lord just pointed out, there is more than one ground. So they can't mean the only ground and no other contributory factor. That can't be what they mean because it wouldn't make sense in the context of this case.
So really it's a surplusage, isn't it?
I accept that, my Lord. I accept that. And under my next heading, additional materials concerning the directive, I'm going to do a bit of archaeology about the expression solely because.
And in Sharma, President Elias's explanation was that this word was just intended to focus on the particular point. It's a matter of emphasis.
That's right. I'm on my third heading, additional materials concerning the directive, is what this heading is. The parties have treated you in our written cases to a detailed account of the history of the directive. In short, there were attempts going back to the 1980s to introduce a directive geared towards part-time workers. Those attempts failed. And following the adoption of the social protocol, a new approach was adopted of letting the social partners negotiate a framework agreement, which also only required qualified majority support when it came to the council. That was the framework that was put in place. My learned friends place a lot of emphasis on what they say is the confined scope of the framework agreement compared to established discrimination provisions. It is narrow in some important respects. I entirely accept that. I've made the point about the need for an actual comparator. I totally accept that dramatically narrows the potential scope of the directive, of the regulations. It doesn't cover indirect discrimination. So I accept those points. However, none of the materials which learned friends highlight demonstrates any intention to adopt a narrow causation test, or as it were, to permit multiple cause discrimination. We have identified the same words were used in another international instrument which was adopted shortly before the directive, and that is the International Labour Organization's Part-Time Work Convention of 1994. And I'm going to do a bit of a detour into that because it's the only place where any of us have found any explanation from the contemporaneous materials for the words solely because. So the convention itself is at tab 66, page 860. And I'll just mention that while the United Kingdom was a member of the ILO at the time that this was discussed and participated in the discussions leading up to this convention, just for clarity, the United Kingdom is not a signatory to this convention. I'm showing it to you as background for the directive. And you will see in this convention a familiar framework. Article 1 defines part-time workers. There's a description of comparable full-time workers. Over the page, Article 4, measures shall be taken to ensure part-time workers receive the same protection as that accorded to comparable full-time workers in respect of various important aspects of working life. And then in Article 5, measures appropriate to national law and practice shall be taken to ensure that part-time workers do not, solely because they work part-time, receive a basic wage which, calculated proportionately on an hourly performance-related or piece rate basis, is lower than the basic wage of comparable full-time workers calculated according to the same method. So there we have the words solely because, and we can explain why those words are included here, because that is clear from the travaux préparatoires. The discussions which led to this convention took place from the early 1990s, and they involved discussions, they involved representatives from labour groups, from employer groups, and from states. And if I could show you, please, page 1045, which is tab 82. This is the record of proceedings of the International Labour Conference in its 80th session, which was 1993. Over the page, you'll see we are looking at the 5th item on the agenda before that conference, and the item was part-time work. And what you have under that heading is a report of the committee.
I'm sorry, I've not got the right page.
I apologise, 1046.
1046, thank you very much.
There is a report of the Committee on Part-Time Work. So a committee was established on part-time work. It reported into this conference in 1993, the 80th session. This is their report. This is where we find the origin of the words solely because. Before I come to that, I will just point out, it says at the top of this page, 1046, provisional record. It's a provisional record which then gets approved by the conference. And it was adopted, this report was adopted by the conference at that 80th session. I'll just give you the page reference to that. It's page 979. If we look forwards, please, to page 1048, you will see at paragraph 137 at the bottom of that page, proposed amended text for the provision which becomes the clause that we've just looked at. The government members of Belgium, Denmark, Germany, Italy, Luxembourg, the Netherlands, Portugal and Spain submitted an amendment to replace point 8 by the following text. Measures appropriate to national custom and practice should be taken to ensure that part-time workers do not receive lower pay than comparable full-time workers performing the same work or substantially the same work solely because they work part-time. The government members, firstly, there's a discussion about unit wage rates and so on, but a bit further down, the proposed new wording would also encompass the possibility of part-time workers being paid higher than pro rata wage rates, which would have been prohibited under the text of point 8 as proposed by the office. there could be valid economic reasons for the payment of higher rates to part-time workers. Apologise, the bit which I really want is the bit I'm just coming on to now. The amendment also proposed to add the expression solely because they work part-time to cover situations such as the recognition of seniority rights in which there were good grounds for wage differentials, while at the same time eliminating differentials which were based solely on the hours worked. And that, as far as we can see, is the origin of the word solely because. This is the first time it appears in the discussions for the ILO Convention. It makes its way into that. That particular amendment is sub-amended. There are more discussions, but the words solely because make their way into the final drafting. And what eventually happens is that the convention gets put back to the conference at its 81st session. So this committee puts together a draft of the convention following the 80th session, and that is then approved at the 81st session.
Was there an objective justification clause in?
There was not.
Right.
Does it matter how the words came into this convention?
Well, my lord, that is a very fair question. I appreciate the limitations of what I'm showing you. No
one suggesting that the European Council had these travaux in mind when they...
Well, I'm not suggesting that they had the travaux in mind. No. I think the furthest I can go is that they legislated in the context of the ILO Convention having recently been agreed. Now, my lord, it does go a little further than that, and I'll just explain why. Chronologically, what happens is the convention, this convention, the ILO Convention, was adopted in June 94. In September 95, the European Commission began its consultation on a new approach to part-time work in Europe, and they refer to the ILO Convention in that context. I'll just show you, that's at page 922, so we're picking up here the consultation.
Well, let's suppose they did have the ILO Convention in mind, but does it matter how it got into the ILO Convention? I mean, they're just taking it as it is, aren't they?
Well, they're taking it as it is, but the ILO Convention...
In fact, it got in there for a reason which wouldn't be apposite in the legislation that they enacted, because it provides for objective justification.
Well, insofar as that is dealing with the objective justification point, that's right. It may also, though, those words about seniority, one could look at that as ensuring, as the President put it in Sharma, that if one is treating people differently for a reason unrelated to part-time status, then that is insufficient, which now that may also qualify as a justification, or it may be a point about differential treatment. But they make their way into the convention and have a reason there, which my point is not about, as it were, green lighting multiple cause discrimination, if I can put it that way. And the ILO Convention is then part of the context in which the Commission legislates, keeping in mind also that the Convention, as I've shown you, followed a process of engagement by employers, by trade unions, representatives from around the world, all the members of the ILO, as well as states. And that was then the same process that was followed just a year later by the parties, by the social partners, in negotiating the framework agreement. So they adopt very similar language. Now, and I gave you the page reference, but just to make sure that I've made that clear, the
922.
I gave you
922.
922, I think.
922, is that? Yes, 922. Yes, so towards the bottom of 922, just expressed as part of the background under the heading, the need for EU action. And over the page, the point which I just made.
It says see Annex 7. Is that the convention, or what's
Sorry, my lady. Lady, can I pass on that question and come back to it after the short term, and we'll see if we can see if the annex that's referred to is actually the convention or if it's some different document. My Lord, back to your question. This is the only explanation that we found of the origin of those words. That's the point I make. Is what I've shown you admissible for the purposes of interpreting the convention? Yes. On standard principles of international law, it's part of the travaux préparatoires, it would be admissible. Is the convention itself and its meaning admissible for the purposes of interpreting the directive? Yes, because it forms part of the context in which the directive is brought in. So is there a route by which this becomes relevant to us deciding on the meaning of the directive? Yes, there is. I don't want to place too much emphasis on it because I obviously can see and accept the limitations of it, but the fact of the matter is it's the only explanation that anyone has found for the inclusion of those words.
But they are the travaux préparatoires of a different treaty.
Yes, but I rely on them to interpret that treaty, which I then rely on as background for interpreting the directive. That's the way it comes in. But, my Lord, there it is. That's all we have. And I say it's consistent, again, with what the President said in the Sharma case.
Thank you.
Still under this heading of documents relevant, other documents relevant to the Convention, can I just show you the case of Whipple, page 815. 815, please.
15. Okay.
Miss Whipple was a part-time worker who had a 0 hours contract. She compared herself to a full-time worker and who did not have a 0 hours contract. And she said that in order to address what she said was the less favourable treatment, she ought to be compensated by being paid the difference between what she did earn and what she could have earned had her employer demanded the maximum number of hours from her that she could have been required to work. That was her case. I think it's what one might describe as an ambitious case. That was how she put it. It's an ambitious case, but you can see the basic point. Her basic point is part-timers were not given fixed hours. That was the sort of core complaint. And if we pick it up, please, on page 839, at paragraph 52, you'll see there is the reference to clause 4 of the Framework Directive. And going down then to paragraph 54, what is said is, in that regard, first, as already been pointed out, paragraph 42 hereof, clause 4 of the Framework Agreement precludes part-time workers from being treated less favourably than comparable full-time workers on the sole ground that they work part-time unless different treatment is warranted on objective grounds. So we have there this reference to on the sole ground, which is obviously a bit of a more forceful way of putting it than solely because in the directive. And this then gets quoted in many later cases, but you will see from the rest of the judgment, this isn't the basis for the decision. There's no argument in this case about there being multiple causes or multiple grounds. It's just described here as part of the background to the discussion. The basis for this decision is actually about comparability. The court says that the full-time worker and the part-time worker in this case are not comparable because they don't have the same kind, the same type of working relationship, and that's between paragraphs 57 and 62. We don't need to look at those paragraphs, but they do have this significance, which is I'm going to show you a decision in Matthews of the House of Lords, which distinguishes Whipple, and which is also about comparability. So all I need to say for these purposes is that the court in Whipple made its decision on the basis that they were not comparable. They didn't have the same type of working relationship. And that language of sole ground, as I've said, comes up in many later cases. There are others in the bundle. Mr. Mountford, I'm sure, may take you to some of them. But my answer to all of them is, if the court is considering a case in which there is only one ground, then the fact that it regurgitates this language of sole reason or sole ground does not tell you how the court would deal with a multiple ground or multiple cause case. And the only case which really has multiple grounds at CJU level is the Laufey case. My fourth heading is whether the regulations must be interpreted consistently with the directive. And this, of course, only arises if you disagree with me about the meaning of the directive. If you decide that it does not encompass multiple cause cases, then I would say, be that as it may, the regulations do encompass such cases. I showed you that the framework agreement at page 302 itself states that member states may introduce more favourable provisions than those set out in the agreement. It also states that terms which are not defined in the agreement can be defined by member states. I showed you also that the regulations were introduced under section 19 of the Employment Relations Act. Could we take a look at that? It's at page 197. Section 19, subsection 1, the Secretary of State shall make regulations for the purpose of securing that persons in part-time employment are treated for such purposes and to such extent as the regulations may specify, no less favourably than persons in full-time employment. So that is what is required of the Secretary of State, and there is then essentially a discretion left to the Secretary of State to decide how the regulations will be drafted. And you will see under 2 that the regulations may do various things. That is left to the Secretary of State to decide. We have the explanatory notes in the bundle. They are at page 939, please.
There's a distinction drawn in these references between whether the explanatory notes were accompanied the bill, in which case we treat them as admissible, I think, and when they didn't, they were just produced to accompany the Act. They weren't before Parliament, in which case they're not. I think that's what the cases have decided.
And these are the latter.
Well, my lord, you will see that you've caught me off guard with that point, which my learned friends and I have both relied on these explanatory notes, but if they are inadmissible, then we are both wrong. Can I, as it were, to Ben ASH, tell you what I say about it?
My own experience of this, and I've looked at it recently, is that the explanatory notes on the Act pretty well follow the explanatory notes on the bill, but it is worth checking, is what I would say about it.
I'm very grateful for that. We will add that to our list, and if we can, we'll get you an answer over the shorter term.
It does appear that these are the explanatory notes on the Act.
Yeah.
Yes.
On the heading.
Yes. Accept that. Well, shall I show you?
We'll hear you do Ben ASH.
Ben ASH. 940. Page 940, 216, so on paragraph 216, it's explaining why the power in section 19 is necessary. It says the power is necessary because directives which implement framework agreements cannot, by the terms of the agreement, cover pay. However, in relation to part-timers, the government believes pay should be covered at the same time as other employment conditions. The powers under the European Communities Act 1972, which are usually used to implement EU directives, are not sufficiently wide to go beyond the scope of the directive in this way, so the section provides powers to do this. And then at 217, the regulations will primarily address less favourable treatment in non-statutory terms and conditions, as statutory employment rights in the UK do not treat part-timers less favourably than their full-time equivalents. The powers are widely drawn, and the government intends to consult fully on how they should be used by discussing with interested parties and publishing draft regulations for comment. Section 42 provides the regulations will be subject to the affirmative resolution procedure. So the point is simply this. There is obviously an explanation in 216 that is quite a narrow explanation for the Section 19 power. It's simply so that it can cover pay. But then 217 clearly envisages, as the section itself envisages, that it may also be used to depart from the directive in other ways, because it says the powers are widely drawn and the government intends to consult. They didn't consult on the meaning of on the ground that, I should say, but Parliament, if this is admissible, if this reflects what was in the explanatory notes to the bill, was intending to draw the powers widely and to leave it to the Secretary of State to make appropriate provision as he or she saw fit following that consultation.
Do you say that the consultation reference could not apply to pay?
No, my lord, that's not. My point is simply this: that 216
yes.
is explaining that the.
I understand. I understand that 216 provides a narrow explanation for the provision.
Yes, I apologise.
In 217, you say it's wider, and there's a reference to consultation.
Yes, and all I draw from that is that Parliament was intending to give the Secretary of State, as it were, wide powers to decide how to legislate under Section 19. That's the only point which I draw from it.
Right, thank you.
The question is, he could do it. The question is whether it was done. Because obviously there's going to be consultation with interested parties and so on. But
yes.
The most you can say is that the Secretary of State had the power to go widely.
That's correct. And
there's an intermediate position, isn't there, between deliberately going wider and keeping to a narrow view of the directive, even if you're wrong on what it means, which is that there might have been more than one view that could have been taken about what it meant, and it might have been a permissible, one legitimate interpretation of something that was doubtful as to exactly what it meant.
Absolutely, my lord. Absolutely. And I want to ask the question this way. Do I need to show that Parliament, as it were, knew that the framework agreement had a narrow meaning and that Parliament deliberately adopted a different meaning? My answer to that is no. That is wholly artificial in this particular case. There's nothing to show whether Parliament thought the directive had a wide or narrow meaning. If Parliament had taken the view that the directive had a narrow meaning, there is nothing to show that they intended to cleave to that narrow meaning, as it were. All that we have is the language that Parliament in fact used, which is the language in the regulations in a context where it is well established what that language means.
So these regulations had to be laid before both houses for affirmative, to go through the affirmative vote procedure. In those circumstances, are they accompanied by any sort of explanation for members of Parliament by the government?
Can we add that? Maybe.
Yes. And were the actual draft regulations subject to any parliamentary scrutiny? Was there any select committee that would scrutinise those regulations? And if so, was there any report from it?
Yes. Ms. Kelly-Lythe reminds me there was an earlier select committee which involved part-time workers. We don't think...
I mean, actually looking at these regulations...
No, these regulations, I think the answer is no.
No, thank you. Right.
So, my lord, I'm in that intermediate position, I think, which was put to me, or a kind of intermediate position, which is essentially Parliament was entitled to and did legislate in well-known, well-understood language. And to put the point shortly, if the result of that went further than what was strictly required by the directive, I don't need to show that Parliament intended or didn't intend that. I simply say that was within their power to do that, and we can see what they did by the language that they used. And I do want to show you the Matthews case. Did this make its way to you? It was submitted on the portal yesterday.
Yeah.
Yes.
I apologise.
Before you do that, can I just ask how that submission you've just made fits with the submission I think you also make that the departure was, or that the decision not to use the words in the directive was deliberate.
Well, it was, yes, my lord, it was deliberate in the sense that Parliament plainly makes a deliberate choice about the words which it uses. So that's what I mean by saying it's deliberate. And the context here is they are using words which have an established meaning. So that's what I mean by deliberate. Now, I don't mean they were therefore deliberately giving it a different meaning.
No, what you're saying is it doesn't matter whether they were deliberately intending to make it wider, or whether that was their take on what the directive meant.
That's the point I'm making. That just doesn't matter. What matters is what they intended to do in legislation in this country, not what they thought about what the directive required, if I can put it that way. And I'll show you Matthews because a really similar issue arises in Matthews. And my lord, just to say this, what Lady Hale says about this is, I'm not unduly concerned by the case of Whipple and by extension the directive. And I suppose that's a way of putting the submission I'm making to you, which is that you ought not to be unduly concerned by the scope of the directive, because one can see what Parliament meant by the language which Parliament used. Matthews was cited below and relied on below, and I apologise, my fault that it fell through the cracks and isn't in the main bundle.
Yes, but it's reached us as a separate document. Thank you very much.
It concerned part-time firefighters who had less favourable terms and conditions than full-time firefighters. I'll try to locate my copy of it.
I'll open my copy at the moment.
And the issue in the case was whether they were comparable, so whether they were valid comparators, which came down to whether, as the first question, whether they were on the same type of contract. The relevant regulation was Regulation 2.3. I'll show you that, if I may, with internal page 374.
Sorry, page
374. So you'll see at paragraph 28, Regulation 2.3 is set out there. It's been amended since, which is why I'm showing it to you in the judgment. For the Regulation 2.3 is explaining what are different types of contract. And you will see that there is a list of different types of contract. A is employees employed under a contract that is neither for a fixed term nor a contract of apprenticeship. And it was common ground in this case that the claimants and their comparators fell within A. So if that was enough, then the claimants would succeed on this particular point. They would be able to use those comparators. But the argument which was put against them arose out of subparagraph F. And F says any other description of worker that it is reasonable for the employer to treat differently from other workers on the ground that workers of that description have a different type of contract. So the issue was whether F was a wholly separate category or whether employees might fall within F and be treated as being in different types of contract, even though they fell within A. That was the issue. And to understand the way this, the argument came about, can I show you first the dissenting judgment, this time of Lord Mance, on page 392 internally.
What is that? Do you know in the page numbering of the...
It will be 27, 28?
Thank you. 28, yeah.
28. And you'll see paragraph 81, Lord Mance describes clause 3.2 and refers to the Whipple case, which I've shown you. And the point which is being made here is 3.2 in the framework agreement includes on what is on its face a general test, whether or not the employment contracts or relationships under comparison are of the same or different type. And Lord Mant says that in Whipple, the court looked accordingly at all aspects of a part-time worker's contract of employment before concluding, in that case, that it differs as to subject matter and basis. So he draws on Whipple, and then over the page, at paragraph 82, says, in the light of clause 3.2 of the framework agreement, reinforced by the decision in Whipple's case, it again seems to me likely that class F was conceived to introduce a greater element of flexibility than the rigid classification of classes A to E could allow, in order to cater for particular employees or workers who would otherwise fall within one of such classes, and to allow them to be treated differently, and as having a different type of contract, if reasonable to do so. Indeed, unless this were so, Ms. Whipple's framework contract of employment might, even under English and Scottish law, have to be treated as being of the same type as the contracts of the full-time workers with whom she sought to compare herself, contrary to the intent of the framework agreement and directive as explained by the European Court of Justice. So he is concerned that on the argument being advanced in Matthews by the claimants, Miss Whipple would have to be treated differently in under the UK statute than she was in fact treated under clause 3.2 of the framework agreement according to the CJEU. Against that backdrop, I want to go to Lady Hale's judgment for the majority. That is internal page 372, which I will test my maths again. Page 7?
8.
8. Failed then.
Page 8.
It is 8.
Yeah.
Paragraph 24. Explains that the regulation, the regulations were made under Section 19 of the Employment Relations Act 99, which required the Secretary of State to make regulations for the purpose of securing that people in part-time employment were treated no less favourably than people in full-time employment. Without prejudice to that general objective, the regulations were also to comply with the UK's obligations under the Council Directive. And then if one goes forwards, please, to page 10, there is a heading towards the bottom of that page, the same type of contract, and this issue is then discussed over the next few pages, which deal with the language of the domestic regulations and then the purpose of the regulations, and then forwards at what I think is going to be page 13, paragraph 37, Lady Hale deals with Whipple in these terms. The start of that paragraph is a linguistic point, but then if one picks it up at around C, nor am I unduly troubled by the decision of the European Court of Justice in Whipple. The claim in that case to be paid on the basis of the maximum number of hours the worker could have been asked to work when she was under no obligations to do any work at all was clearly outrageous. It's not surprising the court found her work when ask and if you please arrangement was not the same type of relationship as those with whom she wished to be compared. Furthermore, the court was concerned with an employment relationship under clause 3.2 of the framework agreement, whereas we are concerned with the express words of the 2000 regulations. The regulation should be read as going at least as far as the framework agreement goes, but is open to them to go further, as is clear from the broader regulation-making power contained in section 19 of the Act. And I will give you the references to Lord Nichols, who agreed with Lady Hale. That's page 367. Paragraph 1. Lord Hope, who gave a separate judgment, but on page 369 at paragraph 12, said he also agreed with Lady Hale. And for completeness, Lord Carswell on page 382 at paragraph 53. I need to speed up slightly, so I will...
Yes, you've got another 15 minutes, actually, Mr. Jones, but if you want to mortgage your reply time, you can do that.
I'm very grateful for that. Yes, my lord, I'm very likely to take you up on that, but we'll see where I get to for the next 15 minutes. McMenemy. This is page 518, so it's tab 50. one has to approach this case with a degree of caution for a few reasons. I say the outcome is correct. I should make that clear. The outcome in the case is correct. I also say some of the reasoning is correct. But it also contains reasoning which is wrong. And that is what has caused difficulties in this case and in other cases. If we start, please, with the facts on page 522. Down at the bottom of the page, you'll see the facts are not in dispute. The respondents were a large company. They provide business support services throughout the UK. They operate on a 7-day-per-week basis. One of their call centres is at Glasgow, where there are about 120 employees. The claimant was employed as a member of their research team there, as from 98. Initially, he worked on a full-time basis. In April 99, he applied for part-time working so as to enable him to fulfil his childcare responsibilities. He and the respondents reached agreement that he would thereafter work on a part-time basis on Wednesday, Thursday and Friday. Thereafter, he was not allowed time off in lieu when public holidays fell on Mondays, although full-time workers in his team who normally worked on Mondays were given the day off. Then you'll see at 9, the team in which the claimant worked seems to have varied in size, but was of about 8 to 10 full-time equivalent members. For a period, his line manager, Mr. Keeman, worked full-time Tuesday to Saturday. It was made clear to him by the respondents in April 2004 that he was not, when working those days, entitled to days off in lieu when he missed a Monday public holiday. The respondents' approach was in accordance with the terms of the contracts of employment issued by the respondents. Now, pausing there, on those facts, there is not direct discrimination. There is not less favourable treatment on grounds of part-time status, and that's why I say that I agree with the outcome in the case. If you just ask the question, why was Mr. McMenemy treated less favourably than a full-time comparator? It's because he didn't work on Mondays. That is not on its face because he was part-time. And it's also, on these facts, it's not inherent in being part-time because full-time workers didn't have to work Mondays, didn't necessarily work Mondays, and there's nothing to say that part-time workers were precluded from working Mondays. It's perfectly possible that this would be a form of indirect discrimination against part-time workers, but of course that is not unlawful. And the case in part illustrates the problem of approaching this only through the lens of but for, because that was what Mr. McMenemy's representatives emphasised. And I think I can put it this way. You can see that from his point of view, he had been working 5 days a week and then started working 3 days a week. And so you can sort of say, well, but for the fact that I was working part-time, I'd have worked full-time. And therefore I'd have got paid time in lieu for not working on Mondays. I mean, true, but that's strict but for, that's right. But that's why I cautioned earlier, and it comes up in several cases, one shouldn't be approaching this test as though it's just but for. But for does normally work as a keystone in these cases, but it's not the test, and it doesn't tell you what the ground of his treatment is in this case. Now, what I have just said to you is essentially what the reasoning was of the EAT was in the McMenemy case. If you look at page 523, paragraph 10, you'll see how the Employment Appeal Tribunal dealt with it. And if I may, I'll just give you that reference, given the time, and move to my next point, which is that the way that the Court of Session frames the test is somewhat different. If one goes back, please, to page 520, you will see that there is there a discussion of the directive, and then in paragraph 3, a discussion of the significance of the word solely, and what is said towards the end of that is that the impression that would be gained from a straightforward reading of the English version solely does indeed mean that less favourable treatment of part-time workers, which is prohibited by the directive, must be for the reason that they work part-time, and for that reason alone. So that is the way that the Court of Session frames this. And then over the page, 521, at paragraph 5, it is recorded that the parties had agreed that the regulations ought to be construed consistently with the directive. There's the reference to Whipple and on the sole ground. And in paragraph 6, it was common ground that in foregoing cases established the proper approach, and towards the bottom of that, as we've said, the prohibition is against less favourable treatment of part-time workers than comparable full-time workers for the reason that they work part-time and for that reason alone. This necessitates inquiry into the employer's intention in so treating the part-time worker. And I will just show you finally the way in which those get applied in this case on page 525. At paragraph 14, it's just the opening lines of that paragraph. Essentially in the same terms as I just showed you earlier on in the judgment. And this is the language which then, as you saw in Sharma, but in other similar cases, is then relied on as essentially showing that multiple cause cases ought not to be permitted.
I'm not sure why this case has been treated as binding on the question of regulations going beyond the directive, since they didn't, not going beyond the directive since they didn't decide the point. Just being treated as agreed by the parties.
Oh, yes. Well, yes, I see the point. Yes. Well, my lord, I agree and argued.
Well, everybody seems to have treated this Scottish case, down the Court of Appeal.
Oh, I agree, my lord. My final heading, then, the decisions in this case. I'm going to resist the urge to go through them paragraph by paragraph, endorsing everything that is said. I'm obviously in the very unusual position of agreeing with the decisions below, and so it's not a case where I can just zoom in on, as it were, the wrong bit. I will make some headline observations, and I will address some of the points which are made in Lady Justice Lang's dissent in the Court of Appeal. The EAT decision, I'll just show you that. It's page 125. You will know that this is a decision of a three-member panel led by the president of the EAT. This ground is discussed from page 136. It begins, as you would expect in the EAT, with a detailed treatment of the various conflicting EAT authorities. I have avoided those. I think my learned friends and I agree that the ins and outs of those cases are really not the core issue for this court. The EAT's own view on the issue is succinctly expressed from page 145 through to 149. And the points which are made are essentially the same as the points which are made in Sharma. I shan't go through them. I will, because I can't resist it, show you at the bottom of 146, paragraph 67, the tribunal says they would not hesitate to adopt the same approach, in other words, the multiple causation approach that I'm urging you to adopt, were it not for McMenemy, is what they go on to say. Could I turn, with that very brief look at the EAT's judgment, to
that's a small point, really, but
yes.
In paragraph 71, they say that part-time work must be the effective and predominant cause of the less favourable treatment complained of. They've earlier quoted what Mr. Justice Mummery quoted in the O'Neill case from the Bon-Bruxelles case. But what they say in 71 echoes the second paragraph in the quote in Bon-Bruxelles, not the rather broader way of putting it in subpara 3 of the quote.
Yes.
And I mean, that is That's really the decision of the EAT on this, isn't it? Then although they've quoted Bonk-Roussel, they've not actually adopted the very broad approach which appears in subparagraph 3 of that quote. I mean, would that be fair, do you think?
Well, my lord, that would be fair, subject to this observation, which is that the House of Lords in Nagarajan, in that passage which I took you to, you will recall, urged us not to adopt overly legalistic approaches and referred to various different ways of putting the point. I've put it as an effective clause, but I'm not. I see the point that in 71 there's a reference to predominant cause. I'm not, I think, facing an argument that it needs to be the predominant cause. The word...
It need not be the predominant cause.
Well, I'm facing an argument that it needs to be the sole cause.
No, I appreciate that. The test that the EAT seem to adopt is it needs to be the effective and predominant cause, but not necessarily the sole cause.
I agree with that, my lord. And the way I have put it is that it should be an effective cause.
An effective cause, right.
The Court of Appeal's judgment is in tab 5 from page 93. Lord Justice Edis gives the first judgment. I'm not going to go through it, although I, of course, endorse everything that is said in it. I do want to just clarify one point, which is a paragraph 35, I think it is. Yes, paragraph 35 on page 104. You see Lord Justice Edis says, as required by the framework agreement and the directive, those who suffer from less favourable treatment by their employers solely on the ground of their part-time status may obtain an effective remedy by proceedings in the Employment Tribunal. What is at issue is whether the 99 Act and the 2000 regulations also allow that remedy to a wider class of part-time workers than the framework agreement and the directive require. This is the class of part-time workers whose less favourable treatment was not solely on the ground of their part-time status, but was substantially caused by it. And I'm just highlighting that because Lord Justice Edis's judgment is, as I read it, founded on the basis that the regulations go wider than the directive, and there's not a prior finding about the scope of the directive. And I ought just to clarify that, of course, my case before the Court of Appeal is the same as my case before you here, which was a primary case. The directive also covers multiple cause discrimination. But that was the basis on which Lord Justice Edis decided it.
Well, he also agreed with Justice Elias in Sharma,
Yes.
so I'm not sure quite what he was deciding on this point.
Well, my Lord, yes, and one can make the same point about Lord Justice Bean, who agrees at 117, paragraph 100, with what is said in Sharma, but which also, it looks like, from paragraph 99, is really deciding it again on the basis of the scope of the domestic regulations. So I just wanted to flag that. Lady Justice Lang's judgment is the one which I need to engage with in more detail. And I am going to do that by going to 3 paragraphs in particular where, as I see them, the most forceful points in her judgment are made most clearly. The first paragraph is paragraph 66, please, on page 110.
So 66. Thank you.
Starting at the top of that paragraph, in my judgment, it is clear that the test for causation in clause 4.1 is a narrow test. The important words are solely because. That phrase could not be clearer. That phrase is also used in Directive 2, that's the fixed term directive, which has a similar provenance, but that phrase is not used in other instruments about discrimination in employment, as my summary of the relevant provisions in Directives 3, 4 and 5 show, and those other directives are other discrimination directives which use the language of on the grounds that. Now, of course, that is correct, that the solely because language only appears, as we understand it, in the part-time and fixed term context, and different language in other legislation may, of course, be an important indicator that a different meaning was intended. But it is in this context that I do make the point that argument has rather less force in circumstances where the instrument in question is not something which was developed by, as it were, the draftsman's pen in the ordinary way. It is a framework agreement that was negotiated in a separate process, in a separate forum. It was not a normal legislative process, and one therefore in my submission needs to be cautious before saying that the people who drafted the framework agreement must have intended a different meaning to that which one sees in other directives. And of course, on the other hand, where this point does bite is when you look at the UK regulations, which were adopted following a normal legislative process and which do use the same language as is used in other discrimination legislation in this country. I then pick it up again in 66, and that clear meaning is not displaced by appeals to the reference in Recital 11 to eliminating discrimination against part-time workers. That reference must be read in its full context, which I've quoted in paragraph 51 above. Recital 11 doesn't support the idea that social partners had agreed specific measures which would eliminate discrimination. But even if it did, the reader does not know what specific measures have been agreed without considering the actual words of those measures, and in particular the words of clause 4.1. Given the apparent difficulty of reaching agreement and the context, which is fully described in the preamble to the framework agreement, there is every reason to give those words their natural meaning. They represent a compromise between competing factors agreed by the social partners after balancing their interests. Now, on that point, of course, I accept that the framework agreement strikes a balance, and I've made clear a couple of times that various forms of indirect discrimination isn't covered. It's tight in certain respects, so it does strike a balance. It's a compromise in that sense. But in circumstances where the parties did take steps to address direct discrimination, and where there's no record of any attempt or intention to carve out, as it were, multiple cause discrimination, I do say that that would be a surprising curtailment. It would be surprising for the parties to have reached a compromise on that particular issue, and there's no evidence that they did so. The second paragraph I want to show you is paragraph 68. This is dealing with the language of the regulations, where Lady Justice Lang says there's no indication, she means no indication that the regulations intended a different approach. On the contrary, the right conferred by Regulation 5.1 applies only if, A, the treatment is on the ground that the worker is a part-time worker. I'll just pause there. I addressed you on the meaning of only if when we looked at the regulations. It does have to be only if it's on the ground that they're a part-time worker, but that is not the same as saying it has to be only if it's on the ground that they're a part-time worker and there is no other contributory factor.
Yeah, the word only is in the wrong place for that.
Yeah.
Isn't it?
It's in the wrong place.
Yeah.
And then further down that paragraph, there's a reference to multiple grounds. The draftsman knew there could be more than one reason or ground for treatment and chose to refer to one ground in Regulation 5.2 and use the phrase only if. For these reasons, it's clear that the test for causation in the regulations is the same narrow test. Well, discrimination law, this is a discussion which my lady raised earlier on. The words ground, on the ground that, or on the grounds that are both expressions which appear in discrimination cases, and they both accommodate multiple causes. And the word ground in the singular is directed at the unlawful ground here, namely part-time status. That's why it's written in the singular. It wouldn't make sense to draft it in the plural, because there's only one prohibited ground. And the third paragraph I want to go to is paragraph 91. which is addressing Sharma, and halfway down that paragraph says, in relation to the examples in Sharma, indeed in his reply, Mr. Jones had to accept that the examples were imperfect. It's correct that the regulations could go further than any directive, but Elias P. did not explain how the language of Regulation 5.2 shows any such intention. Nor is the example in paragraph 52 persuasive. In that example, there's clear less favourable treatment of part-time workers, even on the solely because test. Now, I'll just pause to say, that reference to paragraph 52 doesn't check out, because paragraph 52 in Sharma doesn't contain an example. So it's not entirely clear what that means, but I think it must be a reference to the example that we were discussing earlier, which is where there's a part-time worker in factory A comparing himself to a part-time worker in factory B. And I've spent some time on that, in part to respond to what Lady Justice Lang says here. My submission is that example is a good example when it's properly understood. You'll see on page 116 that Lady Justice Lang goes on to give other reasons for her conclusions, and I'm not going to go into those only because I think I've covered them in the submissions that I've just made on the paragraphs which I have looked at. My Lord, my Lady, unless I can be of further assistance, those are my submissions.
Thank you very much, Mr. Jones. We're grateful. Mr. Mountford.
Give me a moment, my Lord.
Yeah, take your time.
Thank you very much. My Lady, my Lords, I'm grateful for the opportunity to address the Court. What I propose to do in the time that we have available before the short adjournment is to just deal with 3 points by way of overview. Can I outline what those points are and then go on to deal with them? So, first of all, I would like to deal with the point that I'll describe as apples and pears. So, we say that discrimination protections for part-time worker and fixed-time worker status on the one hand, and discrimination protections for protected characteristics such as race and sex on the other are simply not analogous, and the courts that have treated them as such have been led into error by applying an unfounded, broad protective construction to the part-time worker regulations by analogy to those provisions. Secondly, I want to deal with an issue which I'll call sex discrimination being the ghost at the part-time banquet. And we say that a proper understanding of how the part-time work directive and the regulations have taken the limited form we say they have, and indeed the limited form that in many respects my learned friend concedes they have, involves looking at the history of the part-time work in the context of sex discrimination. So my third point that I want to deal with before lunch is that in my submission, sole causation is acting as an appropriate filter in these cases. We say that sole causation in fact operates to filter what the social partners have chosen to include within the scope of the directive, i.e. clear cases come within scope and more debatable cases where there was no social consensus to legislate fall out of scope. So can I just then deal with the first of those, the apples and pears point? First of all, we say, my lords, my lady, that whenever Parliament legislates on a question of discrimination, the extent of the intervention is always exceedingly carefully calibrated. Protection against discrimination on grounds of protected characteristics, such as race and sex, is at the heart of a multi-decade legislative equality project, reflecting broad-based societal recognition and acceptance that there should not be discrimination on grounds of those fundamental and deeply personal characteristics. But even given that starting point, there are areas of life that discrimination law does not touch at all. Parliament has chosen to intervene in particular spheres, such as employment, education, provision of services to the public, but it has not enacted any general prohibition on discrimination. So in some areas of life, discrimination invites a legal response, and in others, mere moral judgment. Protected characteristic protections are now obviously all consolidated in the Equality Act 2010, but as their predecessor statutes show, they develop separately over time with important differences. And one can see that, for example, from the different range and scope of occupational requirements and exceptions as between race, sex, and age, or the ability in age discrimination to justify direct discrimination, which is incapable of justification in the case of other protected characteristics. So even as between protected characteristics, discrimination protections in law are far from uniform. If race discrimination is at one end of the spectrum, more attenuated rights like age discrimination are somewhere towards the middle, we say that statuses like part-time worker status and fixed-term worker status are at the other end of the spectrum. They are not fundamental or deeply held personal characteristics. People may hold or not hold the relevant status at various times during a working life. We say that they are quite different concepts, and that there is a much greater diversity of views about whether and how far statuses like part-time and fixed-time worker status should be protected in law. And we can see that vividly on the facts of this case, or the legislative history of this case, from the fact that there were so many failed attempts to reach a part-time work directive by conventional means at European level. Dr. Mark Jeffrey's 1998 Industrial Law Journal article, which is at page 1068 in the bundle, we've cited a number of parts from that, and it does invite reading in full, because it is an illuminating explanation of how legislation came to be passed in this area. It explains that there were 9 failed legislative attempts to pass a directive on part-time work between 1982 and 1990 alone. And the final attempt to get a directive passed in a conventional manner in the 1990s saw a number of the protections proposed in previous drafts jettisoned, leading the Commissioner to describe this revised proposal as, I quote, the minimum of the minimum, below which nothing is conceivable in social protection. Even that measure failed to pass in a conventional legislative directive in 1994, and so it's at that point that it was put to the social partners to see what consensus or minimum intervention could be thrashed out between organised labour on the one hand and employer groups on the other hand. After many months, and the court will note that they had to request more time for that negotiation, an agreed compromise emerged. And it is right to say that we don't know very much about how that was thrashed out. As Lady Justice Lang said below, those negotiations effectively happened in a black box, and neither we nor the court can look into them. But we can glean various things from what the framework agreement it says as to the competing interests, and my learned friend fairly acknowledges that there are anxious competing interests on both sides as to how far you go in intervention in that area. So we say none of that is surprising, because if you ask the average man on the Clapham omnibus, they would probably tell you readily that there should not be differences between employees of different races. They shouldn't be treated differently on grounds of race. But a more equivocal answer might well follow if you ask whether part-time workers and full-time workers should be treated the same in all respects. So we say that the limited intervention that is affected in the part-time work directive and in the regulations reflects that these measures are, as I said at the start, apples and pears with discrimination measures concerned with protected characteristics. We don't accept that they are analogous in terms of what they're trying to achieve. We don't accept that they are analogous in terms of how they've been negotiated and calibrated to achieve a particular legislative effect. But the authorities most relied upon by us, by the appellant, are characterised by constructions of the directive and the regulations which avowedly pursue a broad protective purpose. And that broad protective purpose derives, we say, from an unfounded analogy between these statuses on the one hand and protected characteristics on the other. And below, before the Employment Appeal Tribunal, the appellant argued that the approach of effective causation should be adopted consistent with the approach to causation in other analogous statutes, using that word analogous. And the EAT noted at paragraph 27, that's page 134 for your note, that there is not a precise read across from the protection under the Equality Act and under the part-time worker regulations, but nevertheless concluded at paragraph 27 that the basic principle is the same. The EAT then went on at paragraph 67 to conclude that the effective causation approach reflected the protective purpose of the legislation. Similarly, in Sharma, As you've been shown, the President Elias held that any conclusion other than effective causation would wholly undermine the very purpose of the directive. And we say, as to these comments, that they do disclose a key error. We do not agree that the part-time worker regulations are analogous to provisions of the Equality Act or its predecessor statutes. We do not agree that the basic principle is the same, or that a broader construction of the regulations can be sustained by reference to any broad protective purpose. There are, of course, some nods in the relevant instruments in European cases to general principles of equality and non-discrimination. But as Lady Justice Lang explained cogently below at paragraph 93, and that's page 116, it is clear from the other European discrimination directives that the general principle of equality has a range of different expressions in different contexts. In some contexts, concepts of direct and indirect discrimination apply, in some not. In some contexts, even direct discrimination can be justified, whereas in others it cannot. The relevant principle of non-discrimination or of equality is also differently defined in different instruments. So we say that, in fact, one has to look very closely at each measure in its own terms. And as Elizabeth Lang went on in that paragraph to identify, in various ways, the part-time worker regulations are structurally quite different in their approach and more attenuated than other legislative interventions on protective characteristics. No indirect discrimination provision, no ability to rely on a hypothetical comparator, which, given the segregated nature of a lot of part-time work, has a disproportionately significant effect, and an ability to justify direct discrimination. So we say that the approach to sole causation is of a piece with all of those limitations. I think I can probably do my second point just before lunch.
Yes, very well.
So the second point, the ghost at the banquet. It's impossible, we say, to understand how the European or the domestic legislator came to intervene in this area without understanding the interrelationship of part-time worker status and sex discrimination as a concept and indirect sex discrimination as a measure. The principal reason why protections for part-time workers were being talked about in the 1990s was as an offshoot of the discussion of sex equality. Not the only reason, but we said that was the principal driver. And the different treatment of part-time and full-time workers was understood to have a disproportionate impact on women in the workforce, given the much greater likelihood that they would be juggling childcare and work responsibilities and the resulting predominance of women in the part-time workforce. Can I just give you the statistical position, and I take this from page 1059 from the Professor Mark Bell Industrial Law Journal article. At the time of introduction of these regulations at the turn of the century, about 80% of the part-time workforce was female. Even in 2010, that had only fallen to 76%. And we can see this concern with sex equality in the part-time work directive, the framework agreement itself, at clause 6.4. For your note, that's page 302, where it says, this agreement shall be without prejudice to any more specific community provisions, and in particular, community provisions concerning equal treatment or opportunities for men and women. But of course, in the 2 decades prior to the introduction of the directive and the regulations, the law of sex discrimination had not stood still, as women were affected in the workplace by different treatment of part-time and full-time work. Remedies had already been fashioned through sex discrimination law, and the court will be well familiar with the progress on grounds of sex equality made by the law of indirect sex discrimination in the 1980s and 1990s, when the provisions of the Sex Discrimination Act 1975 had come to be used and interpreted by the European courts and the domestic appeal courts. Cases like London Underground and Edwards in the Court of Appeal, in which my lady will be well familiar, demonstrated that facially neutral provisions could be challenged and struck down on the basis of their disproportionate impact on women. That sea change affected by those cases changed the position of part-time workers for both men and women, as employers had to update their approaches to reflect the new law. And this was all noted contemporaneously in the House of Commons research paper, which was made available to Parliament upon the introduction of the draft part-time worker regulations, answering my Lord Richard's question about exactly the moment when that particular document, which we've relied on significantly, was before Parliament. And one sees that in that, I can take these references in light of the time briefly from my skeleton argument at paragraph 37.1.1. It's stated there that largely because of the changes of the law, made as a result of challenges under the indirect discrimination provisions of sex discrimination legislation, that there is relatively little discrimination against part-time workers. So that is what Parliament was being told, at least in that House of Commons research note. Now, of course, not everyone felt that there was little left to do, and I'll come on to show you criticisms that were mounted at the time, but we say that is important context as to why the measures that were ultimately agreed in the directive and in the regulations were modest in their impact and in their scope. Can I just give you briefly the impact assessment scope of coverage of these provisions? As originally drafted, the regulatory impact assessment, and this is paragraph 37.1.3 of my skeleton argument, noted that only 45,000 of the 6 million part-time workers in the UK would be caught in scope of these regulations. After post-consultation amendments to the draft regulations, the updated impact assessment concluded that only 400,000 would be in scope. So only 7% of the part-time workforce captured in scope of these regulations. And we say that is relevant context to understand the limited nature of the regulations, but we also say that it offers some comfort because sex discrimination will continue to provide significant redress in this area of law, pending any further political initiative to revisit or extend part-time worker protections qua part-time worker. And that obviously is, and I'm finishing up now, that obviously is a political issue, where the balance should be struck on the substance of part-time worker protections, balancing competitiveness, regulatory burden on the one hand, and workers' interests on the other. And we say that question of fine political and economic judgment will be assisted by the court clearly confronting, in this case, the limited scope of the legislative intervention in the part-time worker regulations a quarter century ago. It is then for Parliament to consider whether the position needs to be revisited, as Lord Justice Bean contemplated in his judgment. I haven't quite managed to get into my third point, but I'll deal with that after lunch.
We can hear that at 2 o'clock. You can hear that at 2 o'clock, Mr. Mountford.
Grateful.
Thank you very much. We'll rise now. It's possible we may be very slightly late at 2 o'clock because we have to hand down a judgment in another matter, but we shouldn't be long delayed. Thank you both very much.